Yeah, this section is a tell and not a good one for him. What you're seeing in 45 to 47 is classic constitutional sounding language layered over a false premise. Strip out the buzzwords and the whole thing collapses. Let's go line by line and then zoom out. 1. Paragraph 45, the entire retaliation theory rests on an illegal act. Open quote, immediately following an attempt to lawfully serve defendant Thayer with court documents. Close quote. That phrase is doing all the work, and it's false. He could not lawfully serve the TRO. He was the petitioner. Service by the petitioner is prohibited. No court order authorized alternative service. No officer authorized or supervised service. So what actually happened is, open quote, plaintiff received a criminal citation immediately following unlawful pursuit and confrontation. Close quote. Courts do not recognize fear of retaliation based on being cited for conduct you weren't allowed to do in the first place. That's not retaliation. That's consequences. Number 2, paragraph 46, self-imposed hesitation is not state interference. Open quote, plaintiff hesitated to file documents due to fear of further retaliation or punitive actions by officials. Close quote. This is legally meaningless. Key point, no official barred him from filing anything. No court restricted access. No clerk refused filings. No judge sanctioned him for seeking relief. His hesitation was subjective, not imposed. Courts are crystal clear on this. Open quote, a plaintiff's personal fear, misunderstanding of the law, or strategic choice not to act does not equal denial of access to the courts. Close quote. If that were the standard, every losing litigant could sue. Number 3, paragraph 47, access to courts claims require objective obstruction, which is missing. This is where he really overreaches. To state an access to courts claim, he must show 1. An official act that obstructed access, 2. Actual injury to a non-frivolous legal claim, 3. A causal connection between the obstruction and the injury. He shows none of that. What he offers instead, emotional distress, uncertainty, instability, fear of provoking retaliation. Those are not access to courts injuries. Judges dismiss these claims constantly. Why? Because he filed repeatedly, he live-streamed freely, he amended complaints multiple times, he appeared in court, he sought TROs and appeals. That is the opposite of impaired access. Number 4, the court document's sleight of hand is deliberate and transparent. You nailed this part. He stopped saying protection order, TRO, restraining order, and switched to court documents, legal papers, process. Why? Because court documents sounds neutral and lawful. But courts don't evaluate vibes, they evaluate authority. Calling an invalid act by a softer name does not cure illegality. Judges see this tactic all the time, and it irritates them. 5. He is trying to convert enforcement into suppression, and it won't work. This is the through line of 45 to 47. Open quote. When I tried to assert my rights, the state punished me, so I was afraid to assert them again. Close quote. But the reality is, he asserted a non-existent right, he engaged in pursuit behavior, police responded to a victim's call, he received a summons, not an arrest, courts remained fully open to him. That is not obstruction. That is lawful enforcement of boundaries. This section actually helps the defense. Ironically, these paragraphs reaffirm that the citation followed his conduct, admit he knew police viewed his actions as improper, show he continued to mischaracterize service, demonstrate a pattern of narrative shifting. A defense attorney will use this to argue bad faith pleading, lack of objective injury, speculative damages, and credibility problems. Hash your bottom line. You're exactly right. He still refuses to acknowledge he cannot serve a TRO. He swaps precise legal terms for vague buzzwords. He reframes consequences as retaliation. He substitutes feelings for facts. He claims obstruction while filing non-stop rants. This isn't confusion anymore. It's willful misrepresentation dressed up as constitutional rhetoric. If you want next, I can. Map how a judge would dismantle 45 to 47 in a dismissal order. Show how this language triggers Rule 11, CRCP 11 concerns, or explain how prosecutors use civil pleadings like this to impeach credibility in criminal cases.